It's the appointed time and we've formed a quorum. Please take your seat. Can we invite the administration team in? First of all, confirmation of the minutes of the last meeting. The meeting was held on the 2nd of June. The clerk has not received any proposed amendments. Can I confirm the minutes of the meeting? Yes. Can we invite the deputations in as well? I would like to welcome the PAS for Financial Services and the Treasury, Mr. Paul Wong and Ms. Teresa Wong, Official Receiver, and Mr. Alan Chong Ka-ning, Senior Government Counsel, Department of Justice, and the Assistant Official Receiver, Ms. Fiona Lee. Welcome. 3 deputations will be coming here to give their views to us today. So on behalf of the Bills Committee, I welcome deputations and the government team for attending today's meeting. On the Bankruptcy Amendment Bill 2015, you will be giving your views. If you need simultaneous interpretation service, please put on the earpiece and you can select your preferred channel. Channel 0 is floor, Channel 1 is Cantonese, Channel 2 is English, and Channel 3 is Putonghua. I would like to remind deputations that you should pay attention to the notes for members of the public attending meetings in conference rooms or observing meetings in public galleries. In these notes, various security measures have been set out, and the notes have been included in the letter sent by the clerk to you, and the notes have also been tabled. Those attending and observing meetings in public galleries can ask for a copy of the notes from the security staff. Now, I would like to invite the deputations to speak one by one. You will have 5 minutes. You should highlight the salient points in your submissions, and you don't have to repeat all the content of your submissions. In accordance with established practice, all the submissions received by this Bills Committee have been uploaded to the electoral website and have been circulated to members. And if deputations have not sent in your written submissions, or you have supplementary written submissions to make, please provide them after the meeting. I would also like to remind you that for your submissions and your speeches at the electoral, you would not be protected under the Powers and Privileges Ordinance of the electoral. Also, deputations, if you speak, please don't use cocktail language to facilitate the simultaneous interpreters in their work. If you are ready, first of all, I would like to invite the Chairman of Insolvency Law Committee of the Law Society of Hong Kong, Mr. Keith Ho, to speak.
As far as the Law Society is concerned, we have submitted our views by a paper on the 8th of July 2014. In this submission, the Law Society is in favor of the interview approach presently adopted by the proposed amendment. The Law Society would like to support the amendment as presently drafted. At this moment, we do not have anything to add to the submission we already made in July 2014.
Thank you.
Next one is Ms. Pinky Young from the Caritas Family Crisis Line and Education Center. We help the bankrupts who are in the grassroots level and the new amendment bill. We are quite worried bankrupts who are in the lower class, grassroots class, they might be running their business. Perhaps they would be running a boutique in a shopping arcade. And because they have not been managing their business properly, so they go bankrupt. When they meet with the TIB trustee, and they are asked to furnish certain information, but then they are not very good at running their business. So some of their documents may not meet with the requirements of the trustee. So I think in the amendment bill, the provisions will be, these small business owners will be caught inadvertently by the law under the new amendment bill, and the non-commencement order will be issued upon them because they have not been furnishing the proper documents. I'm worried about this. Going by my experience, some intermediaries and consulting companies are handling the bankruptcy procedures for the bankrupts, and when they provide advice to the bankrupts, they are not providing proper advice. So the bankrupts cannot furnish a full set of information to the trustee. So these are innocent bankrupts who may be caught inadvertently by the law, and there would be a non-commencement order imposed on them. Thank you. The next one is from the HKICPA, Mr. Stephen Briscoe.
The profession generally welcomes the proposals set out by the administration. There is, however, some concern regarding exactly what defines initial interview. The proposals as they stand are clear insofar as if a debtor fails to attend the initial interview, it will provide sufficient reason for the trustee to apply to the court for a non-commencement order, meaning that the bankruptcy does not start to run. Until the bankruptcy starts to run, the discharge period cannot start to operate. Unfortunately, the proposals do not address the definition of what is the initial interview. On a strict reading of the proposals, it appears that this refers to just one meeting at which the debtor attends on the trustee and provides the trustee with such information as he needs. In practice, in many cases, it's far from being quite so simple. For any debtor whose affairs are in any way out of the ordinary, it's almost certain that when they attend the initial interview, they will provide some, but almost certainly not all of the information required to enable the trustee to undertake a proper investigation of their affairs. This is very likely to necessitate a second and, on some occasions, a third meeting at which this information can be produced. The question which arises is whether or not by attending the first meeting the debtor has complied fully with their obligations, thus preventing the trustee applying for a non-commencement order. In other words, while the debtor may have complied with the letter of the legislation, they may not have complied fully with the spirit of the legislation. Our concern is that a debtor may be regarded as complying with their obligations simply by attending the first meeting, at which they may not provide all the information required by the trustee. If there are no measures in place to enforce their subsequent attendance at follow-up meetings as necessary, there may be no incentive for the bankrupt to cooperate after that, and it creates a situation that would be capable of being exploited by an unscrupulous person. One of the main purposes behind these new provisions is to prevent the bankruptcy period starting to run for discharge purposes if a bankrupt does not cooperate with his trustee. We don't wish to see a situation arise where a bankrupt can attend an initial meeting and then fail to provide all the necessary information to his trustee at that meeting, whilst proposing that he or she will supply the remaining information later. If the bankrupt then fails to supply the information afterwards, the trustee may be in a position where the bankruptcy period has started to run. And because of the lack of flexibility, the trustee can no longer apply for a non-commencement order. We are not suggesting that a bankrupt need to be physically present at any and all follow-up meetings. but there should be a requirement to attend at least electronically, whether that be by video or by telephone, until the bankrupt has provided all the information that the trustee reasonably requires and that the bankrupt is in a position to supply. So in the circumstances, we believe it would be helpful to clarify the meaning of the initial interview to encompass such subsequent meetings as are necessary in order to ensure that the bankrupt provides the trustee with such information as is necessary. We have a second point in relation to the time limit applying for a non-commencement notice. In our reading, there is some ambiguity between making an extension application to extend the time allowed to apply for a non-commencement order and applying for a non-commencement order itself. We're not entirely clear whether the trustee, for example, could apply to the court after 7 months to extend the time limit to make a non-commencement order from the original 6 months to 9 months, or whether any application for extension has to be made before the end of the first 6-month period. Thank you very much.
Thank you. 作為秘書長
PAS, do you have anything to respond? Thank you. Thank you, deputations, for your views. In the character's submission, Ms. Yong mentioned that the bankrupts may be the small business owners and they may not be running their business properly and they may have lost their receipts and they could not be providing the proper receipts and they would be caught inadvertently by the law. Now, I would like to explain how the proposed mechanism works. The trustee in the initial interview should make reasonable requests for information. And we anticipate that in some cases, the bankrupts may not be able to provide the information at the initial interview. So the case is that the trustee should require certain information at the initial interview and require further information after the initial interview. So we can't generalize or make generalizations. And we can't say that in cases where the information cannot be supplied by the small business owners, then the non-commencement order will automatically be made. So every case has to be looked at individually. And we have to also have the test of whether there is a prejudice in the administration of the bankrupt's estate. Only if that is proved, then the non-commencement order can be applied for. And also the bankrupt can have the right to represent to the court and say that the court should not be making the non-commencement order. The bankrupt can make his case to the court and he can explain why it is unable for him to furnish certain information. And the court can have discretion to look at the whole case and consider which side's justifications are more trustable and whether there has been a prejudice in the administration of the bankrupt's estate. If the trustee's case is more acceptable, then only then will the non-commencement order be made. So in our proposed regime, we're trying to strike a balance between the right of the bankrupt and the right of the trustee. So there are different cases, I believe, in reality, and in our design of the proposal, the bankrupt can make a can state his case to the court, and then the court will make a ruling as to which size justifications should be acceptable. The HKICPA made a few suggestions or comments, and the first one is about the definition of the initial interview. Under the 30AB in the amendment bill, it is set out clearly the requirements of the initial interview, and that the trustee can come up with an appointed date, and on that date, the bankrupt will be asked to furnish information on his estate. Well, we haven't come up with a specific provision in the definition section on the definition of the initial interview, but in the proposed 30AB, it is set out clearly what we mean by initial interview.
I'd also like to explain that the designated date means that the initial interview should be for 1 day. That is our policy intent. Of course, people have asked whether or not 1 day is sufficient for the initial interview, and it is difficult to draw the line as to let's say if there are information which had not been clarified during the initial interview and the bankrupt has to provide further information, and if that would be regarded as an extension of the initial interview, and during the extended meeting certain information is still not yet available, will there be a need for a further extension? This will give rise to disputes and also create uncertainty for the bankrupt. So having considered this, and we've decided that for the initial interview, we're talking about an interview that should be concluded in a day. Of course, this would require adjustment in the work of we've proposed that the date is set on for November 1st, 2016. The official receiver's office will need to consider which are the more important information that they need to obtain from the bankrupt during the initial interview, and what are the information that they should require the bankrupt to bring along to the first interview. So there might be some changes in the operation, and we need to do some internal training may be required. For the TIB, again, they will need to know about this change, and the official receiver's office will also inform them of such changes, and the TIB may need to, adjust their, work procedure accordingly. So for the bankrupt, he would know when he would have discharged his responsibility, and for the TIB, he could also adjust his procedure or work accordingly. If the IPCA has pointed out that the bankrupt may not be able to furnish some information, and does that mean that he does not have the responsibility to attend further interviews? That's not the case. Under the existing provisions, there is, the provision regarding the objection regime has remained unchanged. Even the bankrupt has attended the first interview and provided the relevant information, but the situation may develop, and the TIB may require further information. Then the TIB may ask the bankrupt to attend another interview. If the bankrupt does not attend that interview or fail to provide the additional information, the TIB cannot, invoke the non-commencement order, but rather he can apply for a suspension of the automatic, suspension. So it's 4 years for first-time bankruptcy and 3 for subsequent bankruptcies. So there will be sanctions in place and incentives for bankrupt to attend subsequent interviews to provide information to the TIB. So during the initial interview, if the bankrupt cannot provide certain information, then the TIB may consider whether he should apply for the non-commencement order. The TIB will have to decide whether or not the bankrupt is creditable, and believe that he would be able to furnish the information in subsequent meetings. That would be a decision for the TIB and the bankrupt to arrive at. Regarding the application to the court to extend the bankruptcy period, right now, the period it is proposed that the period be 6 months if the TIB cannot complete its work within 6 months, and the court can allow for an extension of a month to 3 months, and during on top of the extension period, the TIB can apply for a further extension. That is the current, system, and I believe that would resolve the concern of the ICPA. Do members have any questions or for the deputations or the officials? If not, then I have to thank the deputations for attending our meeting. You may now be dismissed. Thank you very much. Colleagues, we will now continue with the scrutiny of the bill. Regarding policy matters, if you have any further questions for the government, or if you wish to seek further clarification, well, I think we have a paper, and that is 92 91. Under Secretary, Legal Advisor. Or you want to, make a comment? Let's see whether the government has anything to supplement. Chairman. In this paper, we have responded to some of the questions raised by your legal advisor. We've already talked about the policy objectives, so I shan't repeat that here. Your legal advisor also raised the question about the definition of initial interview. So on page 2 of our paper, under point number A, we've already provided an explanation that is in the newly added 30A and B. We have already provided for a definition of initial interview. Your legal advisor also raised a question regarding the non-commencement of relevant period and whether or not the application for an extension is unfair to the bankrupt. We have already explained that it is for the court to decide as to why the TIB would need to apply for an extension. We believe that we have already balanced the interests of both parties. Where there are exceptional circumstances when an extension is warranted, then there is a mechanism for the trustee to apply the sanctions on the bankrupt. Thirdly, the transitional arrangements. In the provision, we've already provided for this, and that is we are proposing the cutoff date to be November 1st, 2016. So any bankruptcy orders made before that date will follow the existing arrangement, and bankruptcy orders issued after the 1st of November 2016 will follow the new arrangement should the bill be passed. Your legal advisor has noted that the CFA is now hearing another case regarding the abscondee regime. If the CFA eventually decides that this provision is unconstitutional, how should we deal with that? So I think the solution to this is very simple. If the CFA declares that that provision is not constitutional, it would mean that the bankrupts who were previously bound by this provision, then the bankruptcy period will start counting from the day when the bankruptcy order was issued, and upon the expiry of 4 years, they will be discharged. we will need to, take up some administrative work. For example, we need to inform the trustees and the bankrupts that should the CFA arrive at such a decision, then the bankruptcy period would already have concluded and we would have informed them. So we need to amend the ordinance because of the previous ruling by the CFA in the previous case, because at that time we already, had the procedures in place. So we will therefore act according to the decision of CFA. So the old system would still apply. The old system which was established after the previous decision of CFA would still apply. Legal advisor, do you have any comments on the response from the administration? Thank you. I have several questions to follow up, Chairman. First of all, in part 1, we asked the government about the policy in respect of the initial interview and what is the policy intent. We know that under the existing ordinance, the requirement for the bankrupt to provide documents and attend the meeting with creditors, actually there are many related provisions already which the bankrupt must follow. There are also relevant sanctions in place. So we would like the government to further explain this. We understand that the importance of the initial interview in respect of the TIB's need to manage the assets of the bankrupt. If we have a new provision regarding the first interview, could the government provide some information to help members understand what are the problems that we are encountering currently? That is, bankrupts are not able to comply with the requirements of the initial interview. I know that the government has mentioned the initial interview, but it has not said that we have, a common problem, and also can we, deal with the problem, by way of the existing provisions. And regarding the initial interview, in the current legislation, and I'm referring to Section 26, Bracket 2 of the ordinance, which requires the TIB, when there are reasonable justification, then the bankrupt will need to provide information. In Section 156, Bracket 1 and 2, it is stipulated that the trustee may, in respect of the investigation of the business of the bankrupt, can make appointment for interview, but it doesn't provide for the relevant time period during which the interview should take place. My understanding of the provision is that at any time, if the trustee thinks that the bankrupt has not provided the sufficient information, the TIB may ask for an interview. I want the government to clarify this. That is, the initial interview is the initial interview referred to under Cap 6A, Section 1, Clause 150. The bill refers to the interview with the bankrupt. Does it mean that after the bankruptcy order has been issued, within 21 days the bankrupt has to provide, evidence or regarding his statement of affairs? And that is ancillary to while providing such a statement, he would also need to, answer relevant questions. Is that the case?
With regard to point number 3, in the amendment bill, we are introducing a new mechanism, and that is a non-commencement mechanism. In Hong Kong's laws, I don't see any similar kind of arrangement. That is a non-commencement arrangement. And under the BO, as what the administration said, there are provisions relating to the discharge of bankruptcy. There is a suspension of the relevant period provided. And you are now introducing this new concept of non-commencement. How does it work? Some deputations also raised that in relation to the non-commencement order, will it create confusion? What is the status of the bankrupt if a non-commencement order is made? And what are the obligations and responsibilities of the TIB under the case of a non-commencement order? Well, there are two different concepts, I believe. Non-commencement order relates to the calculation of the bankruptcy period, and with regard to the bankrupt's status and also the TIB's obligations, they should not be affected. In the Caritas submission, they have also raised a similar view. Will these two concepts be mixed up by people? In our letter, we also asked the administration, have you taken reference from overseas jurisdictions in the implementation of non-commencement order? The administration reply is not exactly the same mechanism is found in overseas jurisdictions. In Australia, there is a concept of initial interview. A TIB may file with a non-commencement order, but then, and also in the UK, the concept of non-commencement order is not there. If the bankrupt doesn't take part in the initial interview or doesn't provide the information, that would be a justification for not starting the bankruptcy period. Well, and there is no concept of a non-commencement order. The same goes to the United Kingdom. The period for discharge for bankruptcy can be suspended if the bankrupt fails to comply with the relevant requirements, and that is similar to the existing provision of Section 30A. So can the administration elaborate or respond to the points, to these points, PAS? I'd like to thank the legal advisor for her questions. With regard to the initial interview, how should it be implemented? Under the existing law, Section 26, there is a general provision, and that is bankrupts should give certain information and to do acts and things in relation to his or her property as may be reasonably required by the TIB. He should be cooperative with the TIB. If the bankrupt doesn't willfully go against that, if he is willfully going against that, then he will be charged with contempt of court. The initial interview is important because if you can't get information or authorization from the bankrupt in the initial interview, it will pose great difficulties in your administration of the bankrupt's estate subsequently. So that's why we propose the concept of initial interview, and this is very important. And we think that there should be a corresponding sanction in the form of a non-commencement order. And I think we should not be just relying on a general criminal sanction, say a contempt of court. So a corresponding sanction should be imposed. Now, if there is a sanction, then the bankrupt will be incentivized to cooperate with the TIB and to end the bankruptcy period or the relevant period as soon as possible. So even if there are general provisions in Section 26 and also 158 of Cap 6, in this regard, we should have special requirements on initial interview, and there should be a special sanction related to it. As what the legal advisor said, in overseas jurisdictions, there are not exactly the same arrangements. We are in a unique situation. Well, the present regime in Hong Kong is similar to that in Australia in terms of the discharge of bankruptcy. And the CFA found that there is a problem with our abscondee regime. So that's why we think that we have to help the TIB to manage or to do the administration of the bankruptcy estate. So that's why we've come up with our suggestion. This is not a problem encountered by other jurisdictions. So that's why we may not have exactly the same regimes in overseas jurisdictions, but then we are still proposing our this new regime. And in other jurisdictions, they are also asking that the bankrupts be cooperative and so on. And the overseas jurisdictions are facing different problems than ours, so that's why they don't have this non-commencement arrangement. The characters in its submission also mentioned whether there will be confusion. Now, if the new regime is endorsed by the Legislative Council, we would put in place a transitional arrangement. We need to train our staff. We have to improve on the computer system. We have to notify the relevant professionals. We also have to notify members of the public, especially the bankrupts. We have to prepare all the public education materials. We have to let them know that non-commencement order doesn't mean that their status as a bankrupt will not begin too. Once the bankruptcy order is made, the TIB has the duty to do the administration of the bankrupt's estate, and the non-commencement order will not affect that. And we need to prepare public education materials which are easy to understand. So this is preparatory work that we have to undertake. Members, any questions on the administration's response? If not, then do you have any other questions as far as the policies of the amendment bill is concerned? Any further questions? Mr. Ng Lang Sing. A simple one here. For all the proposals that you are making, have you considered the aspect of public education? Would you be notifying the affected parties in advance? There may be bankrupts who are uncooperative or who don't comply with the law because they don't understand, and they will be caught by the law. So as far as education, public education is concerned, will you do preparatory work? What are the channels of disseminating such information? Thank you, Chairman. Thank you, Mr. Ng, for your question. If a bankruptcy order is made against a bankrupt, you have to provide information to the bankrupt to let him know of his duties and obligations. We may have to revise the pamphlets and the relevant publicity materials. Mr. Ng asked about whether we can do anything before the commencement of the bill or the ordinance. I think it has to do with financial education. I know that in the Investor Relations Center, they are already doing something. In June this year, they have published certain information of articles on debt management. There are many reasons for people to go bankrupt, and debt is obviously one of the reasons. So I think we are already doing education on debt management. At this stage, some members of the public may not envisage that they will go bankrupt, and maybe there is not a need to do large-scale public education among the general public. I think what we should do is to educate the public on how to manage their debts better, and this is something that has already been done by the investor in the relevant education center. Have some NGOs asked the administration to do preparatory education work? Recently there have been drastic changes in the stock market, and later on there'll be an interest hike, and the people will have negative assets. So this is something that we should do. Public education, I mean. Have you considered whether you should liaise with certain NGOs and provide the relevant public education resources and materials, including pamphlets, hotlines, providing a hotline for people to call, and also perhaps training up people, and so on? Well, I think you should do more on public education. Perhaps you should teach people how to manage their finances more properly so that they will not go bankrupt. And I think the government should work together with the relevant financial services departments to do public education work. Thank you, Chairman. I think Mr. Ng's suggestion is very good. Some members of the public may seek help from NGOs, like Caritas. Caritas is doing exactly that, helping with the bankrupts. So after the new regime is introduced, and if they want us to publish, or if they want to publish some pamphlets, they will ask help from the government, then we'll definitely do that. Perhaps they would like to publish pamphlets, providing information to people who are going bankrupt. Well, the government is more than happy to help them to publish such pamphlets. The official receiver's office has been liaising with NGOs all along, including the Caritas. And our staff will, from time to time, go down there and introduce our work to them. And also, every now and then, secondary schools will ask us to go down there and explain to them what bankruptcy is all about and what are the duties of a bankrupt. If members don't have any further questions, then we will go to the clause-by-clause scrutiny of the bill. We've got a marked up copy, and the paper number is paper number CB 1921/1415(01). So who will be taking us through this clause-by-clause scrutiny process? Chairman, I will do it. It's a long title. There are 3 points to the long title, and that is to abolish the regime under Section 30A(10) of the Ordinance for the suspension of the relevant period under Section 30A(1). And that is the 4-year bankruptcy period for the first-time bankrupt. And the second is to set up a new regime under which the relevant period may be treated as not commencing to run on the date of the bankruptcy order. And thirdly, to provide for consequential and related matters.
So that is the long title. And then clause 1, short title. Mr. Leung, I'd like to ask whether any rules regarding the drafting of the long title. After we've read the long title, we should be able to understand the whole amendment bill. I mean, this is a general question. How can we enable the reader to understand the meaning of the whole or the purpose of the whole bill? First of all, I'd like to know, I mean, your long title is rather long, so I'd like to ask the law draftsman this question. That is there an established standard, say, a long title should not exceed 10 lines? And if you make some, reference to certain sections such as 38 bracket 10, rather than explaining them, you only refer to 38 bracket 10, it would make it more difficult for the reader to understand the meaning of the amendment bill. Could the government explain this? That is, when you, drafted the long title, what rules did you follow to ensure that the reader understand the meaning of the amendment bill? Thank you, Chairman. And thank Mr. Leung for your question. Normally, the long title would be general in nature. It would explain what the bill mainly aims to achieve, but it would not contain too much details. Sometimes, in order that the bill ensure that the bill is not too general, then we would make certain references to enable to tell the public what they need to do directly. The most important purpose of the bill is to amend or scrap the system under 38 bracket 10 and to replace it with a new regime, namely the non-commencement order regime. So the long title would tell everyone the main purpose of the bill. If you want to assist the public to understand the purpose of the bill, normally we would elaborate further in the explanatory note. We would explain what the different provisions would achieve. So there is some flexibility, but it would not be too general, depending on the requirements of the bill. Chairman, what I'd like to know is what are your difficulties in respect of this bill? Section 38 bracket 10. Then if you refer to 38 bracket 10, we would need to go back to the original reference, the ordinance, before we know what it means. So would there be a better way to explain this by normally a simpler way is to point out what the bill aims to amend. When we look at these bills, I think you will need to read the entire bill before you understand what it is about. And the Senior Government Council has already explained that if you want to know the things referred to by the long title, then you need to go to the back for the explanatory statements or the explanatory memorandum. There is no rigid rule, stipulating the length of the long title. I think Mr. Leung's question and suggestion are valid. So we must therefore strike a balance. Originally, we have thought of using rather general terms to describe the system. But in the course of our deliberation, we found that if we use terms or jargons which we understand but the public may not, for example, if we look at 30A, Section 30A is about the relevant period during which the bankruptcy order will not commence. To express this meaning, then it would need a longer, title. So we need to strike a balance. Certain description may, in members' opinion, be better. So in drafting the bill, we've tried our best to strike a balance. All right, shall we move on? Thank you. Next, we move on to Section 1, short title and commencement. So the ordinance may be cited as the Bankruptcy Amendment Ordinance 2015, and also the proposed commencement day is November 1st, 2016. Now, if you have any questions, please put up your hands at any time. All right, shall we move on? Next, amendments to the bankruptcy order. Section 2, bankruptcy ordinance is amended as set out in Section 3 to 6, and then Section 3, interpretation. First of all, non-commencement order means an order made by the court under Section 30A(c) bracket 1. We'll explain this in further detail when we come to that section. Relevant period. In relation to a bankrupt means a relevant period mentioned in Section 30A bracket 1. Under the new regime, this concept would be discussed under 30 capital A and B. So for the benefit of the readers, we've also included the interpretation here so that the readers will understand the definition right at the beginning. And then Section 30 capital A amended. First of all, 30 capital A bracket 1, we add the new 30AC, and that is the discharge of bankruptcy would need to comply with the requirements under 30A1 and also 30AC, namely the non-commencement order. That is, you are not subject to the constraint of the non-commencement order. So for the first bankruptcy order, it's for 4 years. Bankruptcy of previous bankruptcy, it's for 3 years. So that is what add and Section 30AC means. For bracket 2, Section 3 capital A bracket 1 and 3, we repeal under this section, because we've already explained that the relevant period is already defined under the interpretation clause. So it's already provided for under Section 2. Similarly, 30 capital A bracket 4, we have we repeal the grounds and substitute subject to subsection A 4A, the grounds. I'll explain later on the rationale for this, and that is to protect the interests of the rights and interests of the bankrupt. And then part 4, 30 capital A bracket 4, we add after section 30A4, we add 4A, section 4A. A matter referred to in section 30AB bracket 1B bracket Roman 1 or Roman 2 does not form the basis for the grounds set out in subsection bracket 4 if A. The trustee has applied under section 30 capital AB to the court for a commencement order against the bankrupt, and B. The court has approved or dismissed the application. Perhaps I will need to explain how this operates. If you go to the original ordinance, that is section 4 of 30 there are various grounds which explain the circumstances under which the TIB can state its grounds for objecting to the discharge of bankruptcy. For first-time bankruptcy, the bankruptcy period could be extended for 4 years. Further bankruptcies, then the period could be extended for 3 years. That is in the existing system. For example, the bankrupt does not cooperate with the TIB, in which case the trustee can already extend the bankruptcy order. If the bankrupt does not attend the initial interview, or during the initial interview it doesn't provide the relevant documents with reason, that would constitute that would be an incooperative behavior. Some people ask whether or not this would result in a double jeopardy. That is, the TIB has applied for a non-commencement order, and then before the expiry of the bankruptcy period, he would apply for an extension. And then for the bankrupt, this may not be fair. So the design of 4A means that if the trustee has already, pursuant to 30AB, applied to the court for a non-commencement order, if he has already made the application to the court and the court has made a ruling to approve or dismiss the application, then this can no longer become the grounds under 4A to H. So we are drawing the line here. And the trustee will also need to make a judgment. That is, in each and every case, the trustee will need to decide which is the best option or way to sanction the uncooperative behavior of the bankrupt, or to give more incentive for the bankrupt to cooperate with him. So for 4A, if the non-commencement order, I think it has already been approved or dismissed by the court, then it can no longer be used as ground for objection to an automatic discharge of bankruptcy later on. Legal advisor. Thank you. In respect of this section, what I'd like to know is that if the TIB doesn't invoke 30AB to apply for a non-commencement order, then he can still rely on the existing 30 capital A for ABCD and relied on those as examples to apply for a non-commencement order. So the choice is with the TIB. Yes. So there is a situation where if you go to the following provision, that is that there is a time limit for the application for a non-commencement order. But under the current ordinance, there is no time limit. Although the initial interview may take place at the beginning when the bankruptcy order is being executed, but as the trustee, his duties, then he can still apply. I think legal advisor is correct. If the TIB has not applied for a non-commencement order, and if the behavior of the bankrupt during the initial interview is such that he either fails to turn up or has not provided the necessary document, then the TIB can use this as grounds for objecting to an automatic discharge of bankruptcy. It could be a standalone reason for objection. And if he also, the bankrupt does not cooperate, pursuant to 4 ABCD, then the trustee can make a decision. Regarding the time limit, the TIB would need to decide. That is, if you want to apply for a non-commencement order, then he should need to do it within 6 months or apply for an extension. So if he doesn't apply within 6 months, then afterwards he can only invoke the objection regime.
And he can object to the discharge of a bankrupt to the court. And Now, after 6 months, and if the TIB doesn't apply for an extension, he cannot go back and say that he would like to apply for a non-commencement order. That's not possible. Members, any further questions? If not, then please continue. 5, subsection 5, under this section will be repealed. And the same reason applies because the relevant period has been defined under the definitions section, so we don't need to have this phrase under this section, section 6. And the abscondee regime is set out in the subsection 10. So if we abolish the abscondee regime, then subsection 10 will be repealed. And we have to add in a new subsection 10A, and that has to do with the transitional arrangement. And it reads like this. Despite the repeal of subsection 10 by the Bankruptcy Amendment Ordinance 2015, subsection 10A and B bracket 2 as enforced immediately before 1st November 2016 continues to apply to a bankrupt against whom a bankruptcy order has been made before that date. Why we don't mention 10B1, and that's because the CFA said that that particular section is unconstitutional. So Roman letter 1 is inoperative, so we don't have to list it here. As explained before, under subsection 10A, there is a transitional arrangement. Bankruptcy orders made before 1st of November will continue to apply. And bankruptcy orders made after 1st of November will be subject to the new arrangement and will be subject to the non-commencement order. So this is the amendment to the section 30 bracket 10 sections. Please continue. Clause 5 adds in 30AB and 30AC. This is related to the non-commencement of the relevant period. How it works. First, 30AB, non-commencement of relevant period, trustee's application, the grounds and the procedures for the application. So subsection 1, under 30AB, we explained what the trustee is required to do and what is the responsibility of the bankrupt. So the trustee may apply to the court for a non-commencement order against a bankrupt if A, the trustee has required the bankrupt to attend an initial interview on a date appointed by the trustee for the administration of the bankrupt's estate. That is, he would appoint a day and complete the initial interview within a 1 day, and the bankrupt's responsibility is to attend the initial interview. And the bankrupt, bankrupt has to provide the trustee at the initial interview with information concerning the bankrupt's affairs, dealings, and property. These are the obligations of the bankrupts. And under subsection 1B, the bankrupt has failed to attend the initial interview, or Roman letter 2 has attended the initial interview but failed to provide the trustee at the initial interview with all of the information concerning the bankrupt's affairs, dealings, and property as reasonably required by the trustee. And under those circumstances, the trustee can apply for a non-commencement order. It's important that the request is reasonable, and if the application is made, the court will looking at whether these are reasonable requirements. And if the trustee is challenged, he has to explain why his request is reasonable. So that sets out the obligations of the trustees and the bankrupts. And subsection 2 sets out the time limit for application. So that it says here, the trustee may apply for a non-commencement order within A period of 6 months after the date of the bankruptcy order against the bankrupt, or B, a longer period specified by the court under subsection 3. Subsection 3 has to do with the extension application. So it reads like the court may, on the trustee's application, specify a longer period for the trustee to apply for a non-commencement order. So this period is called the extension application period. And an extension application must be made within A, the period referred to in subsection 2, bracket A, and that it is a period of 6 months after the date of the bankruptcy order, or if the court has specified a longer period under subsection 3, that longer period. So that an extension application can be made for more than once, but the extension application must be made within the extended period. So that's the design of the regime. And 30AB, subsection 5, sets out clearly that this section only applies to a bankrupt against whom a bankruptcy order is made on or after 1st of November 2016. So we will try to avoid unnecessary misunderstanding by having this section. Legal advisor on section 30AB, can the administration explain with regard to initial interview? Does it have to be a face-to-face interview, attending in person? Can that be done through video conferencing? The law or the HKIPCAs also raised this question, whether it has to be an interview to be attended by the bankrupt in person at the office of the trustee. Yes. Official receiver, yes, he has to be there in person. Why? We have to make sure that this is the real bankrupt person. We have to check the identity card. The identification process is important, and he has to furnish some other information as well. Let me supplement, Chairman. Why do we build in an extension application regime? For some reasons, maybe a bankrupt cannot attend the initial interview within 6 months. So this extension application regime is in place to help him. Perhaps the bankrupt is staying in an ICU of a hospital, so that's why we need this extension application regime. Mr. Kenneth Lang, I would like to ask a question on 30AB subsection 2 and 4, or 30AB subsection 4. A minor drafting point here. In English, it says 一個嘅延展申請咧，應該咧就係提述嘅期間咧，應該唔係應該。It should be in a there should be a comma as a punctuation instead of using a bracket here. I don't know when you will use a bracket and when you will use a comma. You should rather opt for the use of a comma. Why do you use a bracket for the phrase if the court has specified a longer period under subsection 3? And also another question on 30AB5, 1st November 2016.
On after 呢個日子係基於乜嘢嘅情況定出嚟嘅咧？兩個問題啫。
How did you come up with this date, 1st of November 2016? Thank you, Mr. Leung, for your question. Mr. Chong, please. I would be taking the question on subsection 4, and for subsection 5, I'll defer to Mr. Wong to take that question. Subsection 4, I think you've got a valid question there. If we have parallel meanings in subparagraphs, we have to look at how the text flows to facilitate easy comprehension by the readers. When we drafted this, if you look at the Chinese version, it says that an extension application must be made within the following circumstances. Our focus is on the period. So A, we want to help the readers in reading it. The scenario mentioned in the bracket is a special scenario, and they should be focusing on A, and also B, the scenario mentioned in the bracket, and the phrase outside the bracket refers to the period. So this is a way of drafting the law. The bracket qualifies the meaning of that. All right, subsection 5, PAS. How did we come up with the date of 1st of November 2016? Let me try to explain. Our assessment is this. We envisage, or we hope, that the bill can be enacted by the end of this year, no matter the progress today, and very likely we would be continuing with the discussion after the legislature resumes in October. And if we have the bill enacted by the end of this year, then after that we would be undertaking further preparatory work, public education, notifying the relevant professional bodies like the Law Society, HK, ICPA. We have to make changes to the computer system. And that takes at least 7 to 8 months. We made an assessment last year of the time to be needed. We have to also tender out the revision exercise. So we come up with an assessment of a 10 to 11 months in the preparatory work. What I'm concerned about is the computer upgrading work. If there is a delay in such works, you would not be able to meet the date, 1st of November. Can you change the date afterwards, or what? Official receiver, please. We don't want to change the date. We have considered it. If there is delay in the computer works, we would do the works manually. Well, let me try to reassure members. Even if the bill is not enacted now, we can still proceed with the relevant preparatory work. Based on our present proposals, we can start assessing the user needs with regard to the computer system, and we can do all these before the bill is enacted. This is something that we can do right now. But of course, there are certain works which can only be undertaken after the bill has been enacted, like the tendering exercise and so on. But for other works, preparatory work can start right now. I have a question too. With regard to 1C, you said that the administration of the bankruptcy estate, if there is prejudice because of matters mentioned in 1 and 2, when will the TIB find out whether there is any prejudice to the administration of the bankruptcy estate? There is not yet the initial interview, and the information is not provided to him yet. Thank you, Chairman, for your question. The way the section is written is that if the bankrupt has failed to attend the initial interview and has not provided the all the information, and that would do prejudice to the administration of the bankrupt estate, and because of a lack of information, the estate cannot be sold off, and so that can be considered as a prejudice. And going by past court cases, we haven't got any clear definition on what we mean by prejudice. We will look at generally how the situation is like to assess whether there is any prejudice done. Of course, the trustee has to look at each individual case, and if there is serious prejudice done, then he can apply for a non-commencement order. Now, in Section 30AC, it is set out clearly that the bankrupt has the right to challenge the application by the trustee, and the bankrupt can also make a representation of his own case, and it will be up to the court to make a decision on whether prejudice has been done or not.
If colleagues have no further questions, we will move on. Legal advisor? In respect of the initial interview, according to the provision, and as we've said just now, the principal legislation does not require the bankrupt to attend a so-called an initial interview. Now, with the new provision, I think what I like to know is that once the bankruptcy order has been issued, is it the case that each and every bankrupt must attend an interview under the current system, that is? Director, thank you. Yes, that's true. We would need the bankrupt to come for an interview. So the bankrupt person, we would need to obtain information about the bankrupt. We want to verify the identity of the bankrupt and also the state of his other assets. So we think it is important that there should be this initial interview. Legal advisor. Well, the application could be extended, but the provision does not state that what are the grounds the TIB would need to furnish before it can apply for an extension. I think the first deadline is 6 months. And 6 months is not a too short a period. And looking at the provision, you can allow for an extension, and the number of extension could be more than once. But in this provision, you have not limited, you've not set out the limit for each of the extensions. So it's possible that the TIB can apply for many extensions, so that the extension would be up to 2 years, so that the relevant period is only 4 or 5 years, then is that out of proportion? I know that the bill is silent on this. And regarding the application itself, you have not provided for a form telling the way as to how the trustee may apply for an extension. And is the application unit ex parte? Is it an ex parte application? Can the bankrupt attend as well? And can he also lodge an objection on that occasion? Regarding the application for extension, I think one important, I think in subsection 3, it is said that the court may, on the trustee's application, specify a longer period. As how long the longer period should be, it is difficult to say, because some trustees may take 2 or 3 months, other trustees may take longer, so we need to maintain a flexibility here, depending on the grounds for extension. And the court will look at the grounds provided by the trustee and see whether or not that they are reasonable. It's not the case that if the trustee applies for 3 months, the court will provide for a 3-month extension. So we do want to maintain some flexibility here. As why we've not used a table or form here. This is because each and every case will be different. So so what we're saying is that for the initial interview, the bankrupt would need we can use a form to specify whether or not the bankrupt has attended or not, and so on. But the reason for extension could be varied, and it's difficult to actually do it by way of a form. I understand legal advisor's concern. That is, whether the trustee can apply again and again for many extensions, so that it could be the extension could be up to a year or even two. Operationally, indeed, it is true that there is no ceiling, but at the same time, our design is to allow the court flexibility or discretion. If the trustee applies again and again for extension, then he would need to have very good justification. The court is not a rubber stamp that the trustee cannot simply apply on an extension and assume that it will be approved each and every time. But we do want to provide for some flexibility here, but the court will be the gatekeeper to ensure that the ground for extension, for the application for extension, is justified before granting the extension. Director? All applications are inter partes, meaning that we will serve the application to the bankrupt, then he can attend if he likes. So it is inter partes. All right, Parent Secretary, we can move on. We move on to 30 capital AC, non-commencement of relevant period, court order, and trustees' notice. And this is mainly about the court granting the non-commencement order and the commencement of the relevant period. 30A already provide for the grounds for the trustee to apply. 30AC1 is about how the application is done. That is, on an application made by the trustee under Section 30AB bracket 1, the court may approve the application and make a non-commencement order against the bankrupt if A, it is satisfied by the trustee as to the matters mentioned in Section 30AB bracket 1 bracket A, B, and C, namely that he has already specified a date requiring the bankrupt to attend the initial interview and he fails to turn up, or in the course of the interview he failed to provide for evidence which has reasonably been requested, and C, such behavior, is actually prejudicial to the TIB, or the bankrupt has no justification for not attending the interview. Well, the bankrupt, if he has good reasons, he can lodge an objection as to why the court should not approve that order. So that's what subsection 1 is about. Subsection 2 is about the non-commencement order. So what elements should be included in that order? First of all, it must, for example, include Roman 1, specify the relevant period for the bankrupt is treated as not commencing to run on the date of the bankruptcy order, meaning that the relevant period doesn't count doesn't start counting on the date of the bankruptcy order. And also specify one or more terms that the bankrupt must comply with before the relevant period is commenced to run. So what he has to do before the non-commencement order is dismissed. And B, may specify any other terms the court thinks fit. So for these terms, they are not about the resumption of the relevant period. It's about other provisions. So having talked about what elements must be contained in a non-commencement order, subsection 3 is about the conditions under which it's about the terms specified under 2 bracket A bracket 2 are complied with by the bankrupt. The trustee must, within 14 days after the date on which all such terms are complied with, as I said, the court has already specified 1 or 2 terms in the non-commencement order. Then the TIB should, 14 days after those terms have been complied with by the bankrupt, A, file with the registrar a notice stating the fact and the date on which all such terms are complied with. So saying that the bankrupt had on a certain date satisfied all the conditions, and also send a copy of the notice to the bankrupt himself, and also where the trustee is not the official receiver, namely a copy should be sent to the official receiver. And 4, bracket 4. On the trustee's filing of the notice mentioned in subsection A, 3A, the relevant period is treated as commencing to run on the date stated in the notice under that subsection. So it doesn't commence on the date of filing. So if the file said that on the 1st of July 2015 he has satisfied all the conditions, then we will start counting again from that date. And subsection 5, this section is without prejudice to any power of the court to amend a bankruptcy order. So this is simply, to avoid any misunderstanding. Mr. Leung Sing, in respect of bracket 3, the 14 days, what is the justification for setting it at 14 days? And you say that if the terms specified are complied with by the bankrupt, would there be any dispute over the calculation of the 14 days? I think the 14 days proposal the 14 days are proposed based on the operational experience of the official receiver's office. So we believe there should be a reasonable period. You cannot, for example, shouldn't allow the bankrupt to only so the trustee should inform the court that all the conditions be complied with so that the reference period can start counting again. And I don't think there will be any major disputes. Because it said if there's one condition, then it will start the reference period will start counting from the date that condition was satisfied. If there are several conditions, then it will start counting when those conditions are complied with. Should there be any dispute, the trustee will say the date is July 1st, 2015, and the bankrupt said, I've already done it, at an earlier date. Then under the existing ordinance, we have a mechanism to deal with such disputes. But I believe both parties, as to when it has been complied with and so on, I think the trustee would have already explained clearly to the bankrupt. So I believe any such disputes would have been resolved at that stage. For example, the trustee said, I don't think it's March 2015, and then the bankrupt may not need to resolve these disputes, going through the court. Legal advisor. Regarding 30 capital AC, subsection 2, you in respect of the non-commencement order, the court may specify certain terms. Could you give us some examples as to what these terms are? Or are they only requirements for the bankrupt to provide documents or the need for him to attend interviews?
Will terms go along those directions? And also in B, the court may also specify any other terms the court thinks fit. Are there examples of these any other terms? What kind of any other terms are you referring to? Let me answer the first part of the question. Specify one or more terms by the court. If we go later to look at the forms, then we will have a clearer idea. The trustee may suggest certain terms to be included before the relevant period starts to count. The court can accept some terms and can accept all terms. The terms may vary, but we can imagine that, for example, if the bankrupt hasn't turned up for the initial interview, then the term obviously is for the bankrupt to attend the first interview or initial interview. Or if there is any missing information, then such information should be provided. So these may be examples of terms to be specified. And the official receiver, please take the question on subsection B. B will not affect the non-commencement period. Any other times, we can imagine that the court may say that if you change your address, you must notify the ORO. If you change your job, you should also notify the ORO and the TIB. So these may be examples of any other terms, and they won't affect 2A2. Any other questions, members? If not, then please continue. Then we move on to the principal legislation, the last section to be amended, 30B. This is an existing provision, and that is a bankrupt can, on his own initiative, ask for a discharge or apply for a discharge of bankrupt if he can satisfy conditions set out in 30B. We're not changing anything substantial here. These are textual amendments to dovetail with the implementation of the new regime. 30B bracket 1, we repeal the words under section 30A because the relevant period has been included in the definition section, so we don't need the relevant period under section 30A. And also bracket 2, subsection 2, we change the way it is drafted. If the bankrupt has been repealed and substituted with if, and in the in section 2A we add in the word the bankrupt has, and that helps readers in understanding what the bankrupt has to do in the following. Though that makes the wordings clearer, and also we are having the same treatment for subsection 3, and also 30B2 bracket I, and we have repealed the bankrupt, the word bankrupt, and we have these are all technical amendments. We have added in the last section where the bankrupt cannot apply for an early discharge of bankrupt, and that is the relevant period for the bankrupt has not commenced to run pursuant to a non-commencement order. So if a non-commencement order has commenced, has started to operate, then the bankrupt cannot apply for early discharge of bankrupt. The reason is obvious, because a non-commencement order is in place. All right. Part 3. We are making consequential amendments to bankruptcy rules. Clause 7 amends Cap 6A, and clauses 8 to 11 sets out the amendments to the bankruptcy rules. We set out what the hearings should be held in court, and we add in EA applications under Section 30AB of the Ordinance for a non-commencement order has to be heard in a court. So we have to add in this to dovetail with the implementation of the new regime. And Clause 9 amends Rule 89.1, and that is to repeal the lifting of suspension of discharge, because the relevant period has been provided in the definition section, so we don't have to give further an explanation to the term relevant period. And Clause 10 amends Rules 89A and 89B. We would be adding in the detailed procedures for application for non-commencement order. If the trustee is the official receiver, and if he applies for an application for applies for a non-commencement order, he has to make a report or provide a report. And if he is not, the trustee is not the official receiver, he has to submit an affidavit. And what should be the content of the report or the affidavit, and the matters that have to be set out in subsection 2. The reasons why it appears to the trustee that the order should be made. And B, if the application is based on the fact that the applicant or the bankrupt has not attended an initial interview, that is in Section 30AB1B1 of the ordinance. The particulars of the steps taken for notifying the bankrupt of the time and place for the initial interview should be set out. So this is to let the court know that the TIB has taken reasonable steps to notify the bankrupt, and that is say he will not be meeting the bankrupt in midnight and somewhere in Lantau Island. And C, the terms proposed to be complied with by the bankrupt for the relevant period to commence to run pursuant to Section 30AC4 of the ordinance. For example, the bankrupt has to attend the initial interview, or he has to furnish certain information. So all these terms would be set out in the report or the affidavit. Subsection 3, the court must A, fix the date, time, and place for hearing the application. And B, give notice of the hearing to the trustee and the bankrupt. And subsection 4, the trustee must send a copy of the report or affidavit to the bankrupt so as to reach the bankrupt at least 21 days before the date fixed for the hearing. And the bankrupt may, not less than 7 days before the date of the hearing, file in court a notice specifying any statements in the trustee's report or affidavit that the bankrupt intends to deny or dispute. And the bankrupt must, not less than 4 days before the date of the hearing, send a copy of the notice under sub-rule 5 to the trustee, so that the two parts are in full grasp of the proceedings. And subsection 7, if the court makes a non-commencement order against the bankrupt, the trustee must, within 14 days after the date of the order, send a copy of the order to the bankrupt, and where the trustee is not the official receiver, the official receiver. So this is the details of the application set out in 89A and 89B, we add in a provision, and that is the trustee's notice filed with the register under Section 30AC3A of the ordinance must be in a prescribed form. And this has to do with Part 4 in relation to the specified forms. That sets the legal basis for us to specify forms. So that's the 89B. And 91, there is an amendment. 91 1. And these are textual amendments under subsection 4. After subsection 4, we add in subsection 5. Particulars of any non-commencement order against the bankrupt, if the situation warrants it. So this is to dovetail with the new regime. It's now 12:25. I suggest that we extend the meeting time by 15 minutes. Any objection? No? No objection. Thank you, Chairman. On the application procedures, I noticed that for every step there is a time limit. Are you taking reference from similar arrangements under the BO? For example, the suspension of the relevant period, and also the fee, the application fee, how will it be calculated? The official receive, if I can supplement later. Yes, we are taking reference from the existing time limits or dates. And also the application fee. In Part 4, we recommend $528. There are two reasons. We have taken reference from existing fee level, and we have made an estimation of the administrative work required, including the administrative work of the court. And we have reached a consensus with the court, and we should take reference from the existing fee level, which is $528, which is a reasonable fee in our view. All right, let's move on to Part 4, and that is the amendments to bankruptcy forms, or specifying new forms to help us with our work. We will be amending Cap 6 Subsidiary Legislation B, Clause 13. We would be adding in two new forms, 82A and 82B. And that is the notice of a commencement of relevant period for bankrupt under Section 30AC of Bankruptcy Ordinance, and also 82A, order for non-commencement of relevant period for bankrupt under Section 30AC of Bankruptcy Ordinance. So these will be added, 82B and 82A. These are two new forms to be added. After 82, now we will add in a new form, 82A, and that is in relation to 30AC and the order for non-commencement of relevant period, the application for a non-commencement order. So the title will be here is the order for non-commencement of relevant period for bankrupt. So on page 11, well, the name of the bankrupt has to be filled in. And we said that there will be an affidavit which has to be submitted or filed. If the trustee is the official receiver, a report has to be filed, and if it is not the official receiver, the affidavit has to be filed. So the date of the filing has to be filled in. And for C, we have to specify whether a hearing has to be held or a hearing doesn't have to be held. And then also the insert the date of the bankruptcy order when the bankruptcy order against the bankrupt will take effect. And also E, delete as appropriate. 1. The bankrupt has failed to attend the initial interview, or the bankrupt has attended the initial interview but failed to provide the trustee at the interview with all of the information concerning the bankrupt's affairs, dealings, and properties as reasonably required by the trustee, and that has appeared in the principal legislation.
Failing to attend or attending the interview and yet failing to provide the relevant information. And if that should happen, the court would come to the conclusion that the assets of the bankrupt has been prejudiced, and if the court thinks that there is no sufficient ground pursuant to 30A(c) for not issuing a commencement order, say the bankrupt has not contested case, and if the court thinks that the challenge is not justified, then it will issue a non-commencement order. So first of all, there is the commencement date. So to avoid misunderstanding, we will stipulate the commencement date again here. And secondly, during the bankruptcy period, pursuant to Section 30, capital AC, bracket 3 and A, the relevant period for the bankrupt does not commence to run until the date as stated in the trustee's notice, and on which all of the following terms have been complied with. So the court would need to look at the relevant information and then lay down the requirements, say requiring the bankrupt to attend an interview, providing his records of his income and so on. So all these conditions will be spelled out, here. And the director also explained that the court can include other relevant conditions, but this will not affect his lifting of the non-commencement order. And of course, the court will need to inform the TIB and the official register. The purpose of the form is to help the bankrupt understand that this is how the court will issue a non-commencement order, and also clearly laying down all the conditions that have to be complied with. So that's the new 82A form. Form 82B, notice of commencement of relevant period for bankrupt under Section 30AC of the Banking Ordinance. That is, there's no need for another hearing. Only filing would be sufficient. So, at the being said, take notice that a bankruptcy order was made against a certain person on a certain date. That's B. And in order that the relevant period for the bankrupt is treated as not commencing to run on the date of the bankruptcy order was made on a particular date. That is the commencement date of the bankruptcy order and the commencement date of the non-commencement order. And then, bracket 2, pursuant to Section 30, capital AC of the Bankruptcy Ordinance, I, namely the trustee, confirm that all the terms imposed by the court for the commencement of the running of the relevant period for the bankrupt, as specified in the non-commencement order, was complied with on a particular date, such that the relevant period is treated as commencing to run on that date. So it will start running from the date as stipulated in B, and then date of filing and also signature. Any questions? We'll move on to the last part, Part 5. Thank you. Well, Part 5 is the amendment to the bankruptcy fees and percentage order, because the court may conduct a hearing, look at all the documents and come to a ruling. So we therefore will need to provide for the fees here. So So under the bankruptcy bracket fees and percentages order, we've added 6A, that is application under section 30, capital AB, for a non-commencement order, a fee will be charged at a rate of $528. Because the court doesn't need to conduct further administrative work or some minor administrative work, so no additional fees will be charged. Any questions from members? Colleagues, if there are no questions, then a legal advisor. Thank you. Having gone through the bill, I think the initial interview is a very important part of the proposal in the bill, and they have been referred to in many of the sections of the bill. Will the government consider providing a clear definition for initial interview, other than explaining its meaning? Can you also indicate in which provisions the term appear? In many of the written submissions, references are made to the initial interview. And does it include just the initial interview, and will it include subsequent interviews because of the need to reschedule and so on? So do you need to provide for a definition for initial interview? Thank you, legal advisor. As I said in my response to an earlier question, under 30 capital AB subsection 1, we have already laid down the requirements in respect of the initial interview, although it is not in the form of definition or interpretation. To address the concerns of some deputations, for example, whether the interview should be for a day or would it be extended to the following day and so on, we think that in the original draft, all these have been clearly accounted for. So there may not be an urgent need for us to add another interpretation for initial interview, because that interpretation will not be very much different from what we find in 30AB. And we will not stipulate that it will only be for 1 day and not for 2 or 3 days. In English, we say on an appointed date. I think that is already very clear that it means a day, 1 day. So whether you put it under the interpretation section or in the bill itself, I think that there wouldn't be any major difference. But then we are still grateful to the comment by the legal advisor. Right. If there are no further questions from colleagues, a brief one regarding fees. How long has this fee been enforced? So this is a new fee set, but we've made reference of the fees payable for similar applications to the court. So I think it's more or less the same. So in future, if we want to amend the fees, we'll need to amend the legislation. Yes, if it is very outdated. Yes, on the point taken. And that is why we already liaised with the court. We are satisfied that the $528 is an appropriate level. Thank you. If members have no further questions, we have then concluded our scrutiny of this bill. We will be going into recess soon, and we will report to the House Committee on the 9th of October. So may I ask the administration and colleagues whether you intend to move any CSAs? No? None. If that's the case, then we can report directly to the House Committee. And I don't think we need to meet in September, unless any member should raise any policy issues and require the government to clarify All right. If there are no further questions or comments, I'll ask the clerk to liaise with the government, because the government will have to tell us when you want to have the resumption of the second and third reading. Okay, we'll take this up with your clerk. And regarding the submissions made by the deputations today, I hope you can also prepare a written response to that. Legal advisor, since we have progressed very expeditiously, I will go back and consider the response by the administration again, and if need be, I'll write to the government and raise whatever issues which I may need to raise. All right? Anything else from members? If not, then I declare that the meeting is adjourned. Thank you very much. We have successfully concluded the scrutiny of this bill. Thank you.